I'm Ann Petrick, Vice President of Research for Vistage. I'm happy to host the latest webinar in our Peak Performer webinar series. This series is designed to support your leadership climb by bringing the most trusted experts to the Vistage community, those who provide exceptional insight and best practices to help you navigate new challenges and possibilities. One thing that's on the mind of many CEOs is when to sell the business. There are many components of planning for and executing the sale of a business, including protecting yourself and your personal funds, the dispersal of proceeds, and your involvement in the company following the sale. Each of these scenarios create different opportunities for liabilities. That's why we've invited Vistage member and speaker Hillel Presser to walk through the important questions to ask yourself and crucial steps to take to ensure that everything you've worked so hard for is protected in the event of a business sale. As a founder and managing partner of the Presser Law Firm, as well as Vistage member and speaker, Hillel represents individuals and businesses in connection with the establishment of comprehensive asset protection plans that incorporate both domestic and international components. He's been featured in media and press internationally, including Forbes, Sports Illustrated, and The Robb Report, along with various network television stations. Hillel has represented some of today's most well-known business owners, doctors, celebrities, and professional athletes, and is also available to come to Vistage groups as well. So welcome, Hillel. Great to have you back, and let's turn it over to you.
Thank you so much for having me, and thank you for the kind introduction. Hopefully I can live up to those nice words. We're going to cover a lot today. Of course, I'll save some time at the end for Q&A. And I would encourage anybody listening, if any questions come up along the way, please feel free to write them down. It's probably the only time you can ask a lawyer a question and not get a bill. So definitely take advantage of that. So probably the first question I always get asked is why I became an asset protection attorney. And as far back as I can remember, if you would have asked me when I was 10 years old, I would have told you hands down that I was going to be a lawyer. Now, it probably had something to do with the fact that at that point, I was very close with my Uncle Jimmy. And Uncle Jimmy was one of the first personal injury attorneys to ever advertise on TV. And while I simply knew him as Uncle Jimmy, the rest of the world knew him as Jim the Hammer Shapiro. And he'd get on TV and he'd scream at the top of his lungs, "I'm Jim the Hammer Shapiro. I'll wring out every penny, squeeze out every dime. You don't have to like me, just make sure you call me. I may be an SOB, but I'm your SOB." And instead of doing his ad, I'm going to take about 30 seconds and just show you one of his many ads.
Hurt? I cannot rip out the hearts of those who hurt you. I cannot hand you their severed heads. But I can hunt them down and settle the score. I'll squeeze them for every dime I can. Every single dime. I'm Jim the Hammer Shapiro. But I cannot proceed until you call. 1-800-546-7777. You call, I hammer.
Now, because we only have a little bit of time here, I won't show you my favorite ad where his face actually pops out of the zero of the 1-800 number, but I think you get the point. And I don't show you these ads because I'm proud of Uncle Jimmy. I show you these ads because this was 30 to 40 years ago in upstate New York. Today, this is the norm. Every bus bench, who can I sue? Every radio ad, who can I sue? Every TV ad, who can I sue? How do I take the money out of the hardworking business owners like yourselves and redistribute the wealth? So there's lawyers in literally every city trying to find a way to take your money. I thought it'd be pretty neat to be one of only a few in the entire country that teach you how to protect it. So why do you even need asset protection? I showed this cute little cartoon and it's two lawyers talking. One says, "I say sue." The other one says, "anyone in particular." And I always get smiles and laughs when I show this, but this is the reality. Just like we're smart enough to join Vistage and get together with our Vistage members once a month to help each other, the lawyers are getting together and they're saying, who's our next target? There's 100 million lawsuits every single year, and that number is only growing. Lawsuits have literally become the next biggest business. And in a bad economy with a potential recession coming, lawsuits always go up. There's a 1 in 4 chance you will be sued in the next 12 months. And the average person and business is sued 5 times over their lifetime. There's a 50% chance of divorce. When I give this speech in Miami, I say there's a 99.9% chance of divorce. And a lawsuit can cost you tens of thousands of dollars, even if you win the case. So the trick is not making money, it's keeping it. And the challenge that I give to every Vistage member, because I know what it's like, guys, I'm a Vistage member, it's all about growth, 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 is for every 60 minutes you spend making money, stop and spend 60 seconds thinking about how to protect it. So why do we need asset protection? When I was doing these stats, I was shocked. 55% of US companies fail or lose more than 40% of their gross revenues within 5 years of a business sale or a transfer of ownership. Think about that. 5.5 out of every 10 businesses either fail or lose at least 40% of their gross revenues when the business is sold or when the business changes ownership. Even worse, 74% of businesses that are going to be purchased either end up not being purchased or end up in litigation sometimes within 10 years. So I know it's crazy to think you sell your business, you think it's a happy day, but believe it or not, the biggest lawsuit that I see that people come into my office for are when they sell a business. Think about it. Nobody ever runs that business like you. Income goes down, expenses go up, and then 2 years later, they turn around and sue for fraud. I call it renegotiation. So the minute you sell your business, you want to take your chips off the table. And if you haven't sold the business, you want to plan accordingly so you sell it correctly where there's no risk of a clawback. So different liabilities, essentially, and triggering causes for litigation threats. Number one, the value of the businesses preparing for exit is probably the most commonly disputed issue involved with business partnership litigation. I've seen it all. I had a client come into my office who, before they even came into my office, spent over $10 million in legal fees defending themselves because they sold the business and the buyer ran it to the ground and called it fraud. Well, in that specific case, the buyer's brother was the CPA that did the valuation. So I don't know who the buyer could have had better to them to do the valuation, but there's always fights about valuation. And don't forget, you can sue for anything. So any lawyer will take that case for free on a contingency fee basis, and then it costs the seller millions and millions of dollars to defend themselves, which a lot of times forces a settlement for the buyer. Preparation for exit can cause emotion to run high, creating additional opportunities for dispute. Anybody who's even thought about selling their business knows exactly how emotional it is. You know, the day before you're supposed to sell the business, you're going to sell it, you're not going to sell it, you're going to sell it, you're going to sell it. Things are always changing. So when you have an environment that's so highly emotional, both on the buyer and the seller side, it always causes friction. And unfortunately, a lot of times people act based on emotion rather than based on law or facts. And obviously, the new owners are going to want assurances about the firm's long-term financial viability and insight into assumptions behind the numbers, which obviously creates post-close liability for the stakeholders. So when I'm dealing with my business owner clients, I tell them, what did you get up front? Oh, $10 million. What are they supposed to pay you over the next few years? $10 million, a total of 20. Presume you're only getting the first 10. A lot of times, and unfortunately, the business owners will do anything and everything to go above and beyond, the ones who bought the business, to find a way not to pay you. So you have to be very careful how you structure the business sale. You always want to get as much upfront as possible. So getting ready for the sale, you always want to involve the experts early. You know, you want to avoid the temptation to essentially avoid the expense until, you know, you really need the experts and the deal is imminent. So many people say, oh, well, I don't need it yet, or, hey, I don't want to spend the money yet. You know, what I've learned is you can either spend the money now doing things correctly, or you can spend 10 times the money later and it probably won't be correct. It's kind of like insurance. You have to get the insurance before you need it, It's kind of like a line of credit. You have to get the line of credit before you need it. So don't be penny foolish, understand, selling your business may be an investment, but probably one of the best investments you can make because you're investing in yourself and your life's work. Also, the right legal structure and planning can help make a positive difference in your bottom line, in addition to ensuring that you keep the benefits of the sale. What I mean by that is, it's not what you make, it's what you keep. It's not what you make, it's what you keep. So you want to make sure that you have a structure set up to receive those assets, maybe from an asset protection point of view, maybe from an estate planning point of view, maybe from a tax planning point of view. Because if you don't have the proper structure set up, not only can you lose all the assets to a lawsuit, but you could pay a lot more in taxes than you legally and ethically really need to do. You want to also mitigate any risk and liabilities through due diligence phase, which will obviously add to your value. So you want to put as much up front as possible. You don't want any surprises. Assume that there's going to be a lawsuit after. Just go into every deal knowing that. It's not if you get sued, it's when you get sued. So the more due diligence that can be done up front and shared between the buyer and seller will at least hopefully reduce that 74% chance of being sued after the sale. And lastly, recognize a strong exit strategy is more than announcing that you're just ready to sell. Take action to protect yourself for your next phase. Don't wait until after the sale to start talking to your CPAs, your tax attorneys, your estate planning attorneys, your financial advisors, your asset protection attorneys. You want your structure set up well in advance, 3 months, 6 months, even 12 months in advance of the actual sale. So why do you need an asset protection plan when you sell your business? Number one, you want to discourage lawsuits. You want to sell your plan. I can't tell you how many times someone's threatened to sue one of my clients. I literally go to the back of the office, get the file, copy it, and mail it to the lawyer. Of course, with a copy of my book. I show them everything my client has and where it is, just the fact that they can't get to it. Now, most of the time, they don't even want to sue my clients, but if they do, you then want to use that plan to negotiate inexpensive settlements. I helped settle a $20 million lawsuit for $250,000. I helped settle a $5 million judgment for $500,000 because they simply couldn't get to the assets. You also want to make sure that you protect your assets from judgments, reduce insurance costs, keep your wealth safe from other financial threats, and most importantly, help you achieve your other financial objectives. And probably the biggest thing, there was a time I was speaking 50, 100 times a year to Vistage groups all across the country. And the biggest takeaway I always saw is that people's financial team were never talking. So you want to make sure that your asset protection attorney is talking to your estate planning attorney is talking to your insurance agent. If your team is not talking, you're more than likely leaving millions of dollars on the table. So 8 keys to a good asset protection plan. Number one, protect every asset. First thing I make a client do when they come in my office is inventory their wealth, because everybody has more than they think that they do. Everybody thinks about their money in the bank or the real estate of their business, but what if you're owed $1 million? What if you have an inheritance of $1 million? What if you have intellectual property like patents or trademarks or domain names? Do you want your domain pointing to the competitor or your phone number ringing to the competitor? So people have so much more than what they think they have. You, of course, always want to keep everything 100% legal. And you always want to make everything as simple and cost effective as possible. People will read my book and tell me they want this big, complex, expensive plan. Start small, crawl before you walk before you run. If your biggest asset is your business, protect your business. Wait a few months. If your next biggest asset is your liquid assets, then protect the liquid assets, and so on and so forth. You want to make sure that your asset protection plan fits your other financial goals. We talked about your team talking, and you want to make sure that it allows you to retain control. Something that you'll always hear me say over and over is own nothing, control everything. Own nothing, control everything. You, of course, want to keep your plan up to date. Hopefully you get an annual physical each year. You should have a financial physical every year. You want to be comfortable with your plan, and it should be totally effective against any threat. It should not matter if your neighbor is suing you, the person you sold the business to, or the best attorney in New York City. Your asset protection plan should stand the test of time. You should be able to take your chips off the table, and you should be able to be uncollectible and judgment proof. So 3 maxims of asset protection. Number 1, protect yourself before you have a problem. You don't buy the car insurance after the accident. You don't buy the life insurance after the death. You have to be proactive. You also want to start with a very basic plan and add firewalls as needed. And most importantly, don't look for a magic bullet or one size fits all. Asset protection planning is not cookie cutter. You need an individualized and customized and tailored plan that meets your specific needs. If I'm helping a client prepare an asset protection plan for the sale of a business, it's a lot different than what I would do for someone who's getting married for the 3rd or 4th time and maybe doing premarital planning, or someone who may be protecting because they have teenage kids driving their cars and they know they could be sued if there's an accident. So there's no cookie cutter. You need something that's specific and specialized to you. Lots of mistakes to avoid, but the 5 biggest ones. Number 1 is hiding your assets. Asset protection is not about hiding. It's not about secrecy. It's about protection. And with a good asset protection plan, you should be able to tell everybody what you have and where it is. They just shouldn't be able to get to it. And I tell my clients, just presume that at some point you're going to have to sit at a deposition under oath or fill out a financial affidavit under oath and tell people what you have. So you want to make sure that your plan has nothing to do with secrecy and everything to do with protection. You never want to go title your assets to straws. I can't make these stories up. I had a guy come into my office. He said, "Mr. Presser, I'm being sued." And he said, "Don't worry, I gave everything to my best friend." I looked him in the eye and I said, "What actually makes you think that your best friend has less legal and financial trouble than you?" The client gave all of his assets to the best friend. The best friend got a divorce, and the best friend's ex-spouse took my client's assets. You don't want to go title all your assets to your spouse. I see this a lot with doctor clients. Maybe they have more liability. Nobody's immune from a lawsuit. Nobody gets up in the morning and expects to be sued. The husband and wife could just as easily get in a car accident taking the kids to soccer practice. And if you shove everything in one spouse's name, you may be messing up estate planning or tax planning. Never commit any fraudulent transfers. That deals with making sure that you're being proactive, and never break any laws. Always keep it legal, always keep it ethical. So hopefully by now we've laid a little bit of a foundation of why people sue when you sell your business. And hopefully we've laid a little bit of a foundation of why you need asset protection, why it's so important. Now let's talk about, how do you literally protect all the assets? How do you protect every asset from everyone every time? And this is probably one of the most important slides I'll show you today, because in the middle, we have something called exposed wealth. And exposed wealth is any asset that's in your name. So I want you to think about it. Do you have any liquid assets that are in your name? Checking, savings, stocks, bonds, CDs, money markets, brokerage accounts? If you have any liquid assets at all in your name, it's exposed and you can lose every penny. Think real estate. Do you own any properties, vacation homes, rental properties, business properties in your name? Well, if they're in your name and you get sued, you can lose it. It's exposed. You can lose every single piece of real estate. And no different with the business. I was chatting with a business owner who was going to sell his business for about $5 or $10 million. Now his revenues are way up. He thinks he can get a lot more if he waits another year or two. Well, he owns the business. So if he gets sued, he can lose the entire business. So just like you need to make sure you protect the liquid assets that are in your name, just like you need to make sure that you protect the real estate that's in your name, if you own shares in a corporation, an S Corp, a C Corp, even membership interest in an LLC, you can lose the actual business. So you want to make sure that you protect those. So anything that's in your name, or even the name of your trust, your revocable living trust, is exposed and you can lose. So how do we fix it? There's 3 main methods. Number 1 is my favorite method, which is transfer it to a protective entity. You've all heard about protective entities, LLCs, limited partnerships, trusts, etc. It's the coolest thing in the world. Just like you and I are different people, we have different social security numbers. If I get sued, you don't get sued. If you get sued, I don't get sued, etc., etc. Well, no difference with your protective entity. You have a social security number and your protective entity has a tax ID. So if you have cash in your name and you get sued, you can lose it. If you have cash in your protective entity and you get sued, you don't lose it because you don't own the cash. And I'm going to come back here in a minute. The second strategy is protect with liens. And I tease here and I say, poverty is power. What is a $100,000 Mercedes worth if you owe $95,000? What is $1 million house worth if you owe $950,000? There are ways to put enforceable liens and mortgages and encumbrances on assets. So if somebody sues you, there's no equity for that person to get. And lastly, convert them into exempt assets. Exempt assets are assets that happen to be protected by state law. And we're going to come back to that in a little bit. So I wanted to start with my favorite, which is transferring the asset to a protective entity. And let's just take a few very, very simple examples. If you take a piece of real estate and it's in your name, well, if you get sued, you can lose that piece of real estate. If somebody gets injured on that piece of real estate, they can sue you and come after everything you own, your real estate, your money, your business. So I never allow my clients to keep real estate, unless it's their primary home, in their personal name for those two reasons. Number one, I don't want them to lose the real estate if they get sued. They work too hard. And number two, I don't want them to get sued if anybody gets injured on the real estate. So we can simply transfer this to a protective entity, in this case, use an LLC. Now, you don't own the real estate, the LLC owns the real estate. So if the property's in your name and you get sued, you lose the property. If the property is in the name of the LLC and you get sued, you don't lose the property because it's not in your name, it's in the name of the LLC. If the property is in your name and somebody gets injured on the property, they can sue you. If the property is in the name of the LLC and somebody gets injured on the property, they can't sue you, they can only sue the LLC. So by using a protective entity, we're getting both inside out and outside in protection. We're protecting the lawsuit from, we're protecting the asset from any lawsuit, and we're protecting you from any injury on the property. This is just one of many examples of using a protective entity. Another example of using a protective entity is with liquid assets. If you have $1 million in a brokerage account, and I don't care if it's 200,000 or 22 million, well, if that brokerage account is titled to your name, you can lose it. If you get sued, you can lose it. So instead of titling it to your name, you can title it to a protective entity. And when it comes to liquid assets, there's things that are much stronger than LLCs. Sometimes we use LLCs, but there's other holding companies like limited partnerships, trusts, international entities, etc. Don't worry so much for today what that entity is. Worry about the fact that you never want to have any liquid assets in your personal name, because if you do, you can lose them. Rather, take those liquid assets out of your personal name where they're unprotected and putting them into some sort of asset protection structure. When I have a client that sells my business, this is the first thing immediately I tell them to do. I spoke to another client this morning who just sold his business for $20 to $30 million. Immediately I told him, when you get that money, and he got some of it already, immediately take those chips off the table. Do not leave that money in your personal name. Put it into one of these protective entities, because if there's a lawsuit in 6 months or a year or 2 years, and they're trying to do any clawbacks, you want to make sure that that money is off limits. People have a big confusion when it comes to corporation and owning their business. A lot of times people will walk into the office and they have a corporation and they think they're protected. And what they don't understand is that corporations, whether it's an S Corp or a C Corp, they're great to protect you from business debts and liability. They are terrible to protect your business if you get sued personally. Let me explain. Somebody owns a business where they digitize books. They go into a school, they take books and they make them digital, and they're doing $5 million a year. If they're operating that business out of a company like an Inc., maybe it's an S Corp or a C Corp, well, the good news is most likely, if the business does something wrong, the business will get sued and not the individual. Of course, the person suing may try and pierce their corporate veil, but for the most part, hopefully the liability will stop at the business. And that's why most people form corporations. They're not doing a business in their own name. Makes total sense. The problem is that nobody ever thinks about it the other way around. When I ask my clients, my Vistage members, what is your biggest asset? Every single one of them says it's my business. That's my cash flow. That's what supports everything else. Well, if you own the shares in your S Corp or your C Corp or the LLC, there's a good chance it's not protected. So if you get sued for a car accident, or maybe your son's driving your car, hits somebody, and they sue you because it's your car, your entire business is exposed. So you want to make sure that we're not only protecting assets like real estate, sales proceeds from a business, but we're also protecting the business itself. So if you're not going to sell the business for a year or two, make sure for that year or two, you're not running any risk. Make sure that you don't own the business, but rather it's owned by one of your asset protection holding companies. We talked on the 3 strategies about exemption laws, and this is really neat. Exemption laws are just state laws that happen to protect yourself. So Florida has great state laws, great exemption laws, and it's no big secret why a lot of the big CEOs who get sued move here, or the big athletes who get in trouble move here. And it's because Florida protects a lot of your assets. So Florida protects your house. You can have a $2 million house in Florida. You can have a $22 million house in Florida. You can have a $200 million house in Florida. If you get sued, nobody can take your house. This is different. If you live in California, your house is probably only protected maybe about 100, 150,000 or so. Florida protects your retirement accounts. You can have 500,000 in retirement, $1 million in retirement, 50 million in retirement. If you get sued, nobody can touch your retirement accounts. You know, in Pennsylvania, retirement accounts are only protected up to maybe it's about 7%, I think, of your total gross you're allowed to put in there, plus or minus. Life insurance, annuities are protected in Florida. You know, in Georgia, your life insurance may only be protected up to $4,000. So you need to learn what are the exemptions for your state and then invest accordingly. So if I have a client and he lives in Florida, I'm going to tell him buy the biggest, most expensive house you can in Florida and pay off your mortgage. Well, if that same client lives in California, I'm going to tell him not to buy an expensive house. And if he does, I'm going to tell him to have a big mortgage because your house in California is not protected. So you want to research what are the exemptions in your state, what's protected by state law. And then when you sell the business, you may want to consider investing those proceeds into assets that are protected. And if you go to our website, it's www.assetprotectionattorneys.com. There's something called financial planning exemptions. And if you hit it, we list what is protected in every single state. So if you're wondering what's protected in your state, just go to the website, click on your state, and you can see exactly what's protected and to what extent. Also, husband and wife actually gives you some protection. I always love when I speak in a room and I get to say, okay, who in here is married? And, you know, maybe 90% of the room raises their hand. And then I like to say, okay, who in here is happily married? And, you know, they always start joking. It's always funny when you have both the husband and the wife in the room. But I say it because a happily married man and woman, or man and man, or woman and woman, equals more protection. So let me explain. There's something called tenancy by entirety, and it exists in about 25 different states. And what tenancy by entirety means is that the assets of both spouses are not subject to the creditors of one spouse. Let me explain. You're married. You have a brokerage account with $500,000. Your wife has a brokerage account with $500,000. If you get sued, you can lose the $500,000. If your wife gets sued, she can lose the $500,000. If you guys instead have one brokerage account, your 500, her 500, so now you have one account with $1 million, and you simply title it tenancy by entirety. Now, if you get sued, nobody can take a penny. If your wife gets sued, nobody can take a penny. So if you live in a state that has tenancy by entirety, you can title assets tenancy by entirety. And as long as only one spouse is sued, which is normally the case, normally when someone sells the business, it's one spouse. Normally when it's a car accident, it's one spouse. Nobody can touch the assets of both spouses. Now, again, it's only for a married living couple. You can't do it if you're divorced. You can't do it if one of your spouses died. It's for a married living couple. And there's really no disadvantage to this, except for the fact that you are commingling assets. So if you're on a second or third or fourth marriage, or if you have some sort of prenup or postnup that you're specifically trying to keep assets separate, that's probably one of the only times you wouldn't want to do that. The only other time is when you have a liability creating asset like a car. But tenancy by entirety, it doesn't cost you a penny, and it's a great first layer of protection. Again, if you're wondering if you have tenancy by entirety in your state and what assets it protects, if you go to the website, again, it's www.assetprotectionattorneys.com. We do have a tenancy by entirety button. You can click it. It'll tell you if there's tenancy by entirety in your state, and also what assets are protected. Is it real estate or is it any asset? Limited partnerships we talked about as a holding company for liquid assets, but a lot of times people say, okay, when do you use the LLC and when do you use the limited partnership? And I like to use them in conjunction. I like to use LLCs for dangerous assets or business activity. So if I'm protecting a helicopter, a boat, a plane, a business, I'm probably going to use an LLC. And I like to use limited partnerships for safe assets. So if I'm protecting things like brokerage accounts, I may rather go with a limited partnership over the LLC. But a lot of times I like to combine them. So you may have a limited partnership that owns the brokerage account, and that same limited partnership may own an LLC that owns a business or a plane. So I know we went really, really quickly, and I'm going to be closing up soon. And please stay on because I want to make sure I answer all of your specific questions. But hopefully today we've laid a little bit of a foundation about how common it is for a person to get sued after they sell a business. Again, the stats even surprised me. 74% of either deals fall through or there's litigation within 10 years of a business sale. And it's because revenues go down, expenses go up, or the buyer just doesn't want to pay you. And what you want to do is, if you're contemplating a business sale, you want to make sure that you protect yourself in advance. So the minute you receive the proceeds, all of those are protected and you don't have to start over after selling your most valuable assets. So just before we close, key takeaways, some of the best things I would tell you to do. Number one is, educate yourself and take a full inventory of your assets. Anybody who'd like complimentary copies of the latest books that we wrote on asset protection, we're going to put a poll up. If you want it on the next slide, feel free just to hit yes. I'm happy to send them to you as a Vistage member at no charge, either ebooks or audio books or physical books. And also take an inventory of what you have, because like I said, everybody has so much more than what they think they do. After you've educated yourself and after you've taken an inventory of what you have, only then can you assess your business risk and issues well in advance of any potential sale. So at that point, you can start architecting and saying, hey, how do I build my financial house? What am I going to need to do based on this building business sale? And then lastly, you want to, of course, start planning early to protect yourself, your partners, and your family. It's a lot easier to make the money than to keep the money. You don't want to have to start over. So you just always want to make sure that you protect yourself. Like I said, if anybody'd like complimentary copies of our books, please just hit the poll. And also, what we're doing special for any Vistage members, as long as you're a Vistage member or you came through Vistage, we're also offering complimentary preliminary consultations. So if you just had a business sale, or if you expect to have a business sale, and you just want to talk more specifically about your situation of how to get protected, please feel free to reach out, and I'm happy to speak to you personally. When it's a Vistage member, I take those cases personally, and I don't pass them along to another attorney. At this point, I want to get into your questions. I just wanted to lay a foundation, but at this point, I want to take any and all questions that you guys have. So please stick around, because I think people will probably ask some things that you want to know. And I would encourage you, if there's anything at all that you're even considering asking, please ask it, because someone else is probably thinking it as well. At this point, I'll turn it back over to you, Ann, and we'll take any and all questions.
Absolutely. I love that you shared the Vistage decision model. This topic definitely fits in the area of financials as well as exit planning, which is under like the whole personal development area of what our CEOs are thinking about. So you talked a lot about the importance of protective entities, and I was interested in that. If someone hasn't thought about their exit plan yet, what's the one next step they could take? Is it the right asset protection plan? Is it researching exemption laws? What's the one thing that they could do?
Sure. So before you start, using the tools or building, you want to do the architecture. I always tell people, think about it like two stages. You don't just go build a house. You don't just go hire a builder. You hire an architect, and the architect goes over all the options. Not necessarily that you choose to do everything the architect talks about, but he tells you all of your options. No difference here. The first step in that situation should be to have what I call a financial architect. So, we look at a client's assets. What are their options from an asset protection point of view? And you need to be so careful, because when you're looking into these options, it's not only about asset protection. You can't have blinders on. You need to make sure that you have what I call an integrated plan. So, we have estate planning attorneys, tax planning specialists, business succession planning specialists. So even when someone comes to me and says, hey, I'm selling my business and I want to be protected, yes, we know that's the most important. However, I need to make sure that that's going to integrate with their estate plan, their tax plan, their business succession plan. Because ultimately, what I want to make sure is I want to make sure while they're alive, everything's uncollectible and judgment proof. But I then want to make sure that when they pass away, all of their assets go where they want them to go, quickly, privately, less taxes and less lawyer fees. So to me, that architectural process, that planning process, is the most important thing. After that, you can take those plans and have the builder build whatever it is. And again, 6 people are going to build 6 different houses or 6 different financial houses. But the first step you should take is to essentially go through that financial planning architecture so you can see every option and then find what's the best fit for you. And there's no one size fits all. There's no one right or wrong thing. Everybody's different, and everybody has a different comfort level. Everybody has a different budget, and everybody's protecting against different things.
Excellent. So all of those components make up a very unique scenario, it sounds like.
Absolutely.
Yes. In the 3 maxims, you said to protect yourself before you have a problem. So if someone has already exited their business, is it too late for them to protect themselves?
It's not too late. And it's also interesting. Even if you've been sued, it still may not be too late. So there's law that says, even if you've been sued, you don't need to stand there like a deer in headlights. And if you think about it, it makes sense, because it may be a frivolous lawsuit. If you lose a lawsuit and there's a judgment, forget about it. It's no longer your money. So once there's a judgment, it's way too late. The best time to plan is proactively. Now, that could be after you sold your business, but there's no lawsuit. To me, that's still being proactive. There may be some liability from selling your business, but at least at that point, there's no lawsuit. And the reason why it's so good to do it proactive is, think about like a toolbox, right? We have hundreds of tools we can use. Well, if you try to protect yourself after you've been sued, which a lot of times you can do, well, you may not have 100 tools in the toolbox. You might only have 8 tools. Those 8 tools may be more expensive. Those 8 tools may not be as protective. Think about it almost like a health issue. If you're getting screened yearly and you catch something early, you're going to be in a much better position to fix it than if you catch it 6 months or 12 months after the fact. So what I tell clients is, if there's a judgment, you can almost always pretty much forget about it. It's usually pretty much too late. The best time to always plan is proactively, before there's any litigation issues whatsoever. And in between, if there is a lawsuit, it's a gray area. There's still times a lot you can do, but just not as much as being proactive.
Interesting. Well, that's good to know that even before the judgment, there still are options. So, but I like being proactive is the best course of action. What common mistakes do you see when business owners are selling a business? What do they make, and what's most common that you see?
Sure. So, a few fold. Number one is, they think that they've been with liability their whole life, and that they've just gotten rid of liability and now they have no liability. It's wrong for 2 reasons. Number one is, you have all the liability from the sale of the business, which I can't stress enough is the biggest lawsuit I see with business owners. But number two, now you're rich. So it doesn't matter if you sold your business for $1 million or 20 million, but I call it the doctor effect. Everybody thinks you're rich. I call it the doctor effect because you may be a doctor with tons of loans from school, but you're a doctor, so everybody assumes you're rich. And when everyone assumes you're rich, everybody wants to sue you because it's easy to get a settlement. So a lot of times, people sell the business. They think, okay, I've had liability my whole life. Now I have no liability, but they really have liability, A, from the person they sold the business to, and B, to the rest of the world who now sees the deep pockets. Again, if they can put together an asset protection plan, they won't have to worry about either of those, but those are probably two of the biggest mistakes that I see.
And when you talk about lawsuits, what are the most common type of lawsuits that someone might engage against a business?
Sure. So, again, when it comes to business, there's business specific lawsuits, but you see a lot of lawsuits for, overtime pay. That's been a hot topic recently. Either not hiring or firing because it's some sort of, selective class, whether that be, age or race or gender or things of that nature. So there's a lot of business specific lawsuits. Also within a business, unpaid commissions. Someone thinks they have a different deal than what the owner thinks they have. Obviously, when they sell the business. So a business has its own set of, just totally special. There's about 5 or 10 of them, and I have a list I can send out if anybody wants it. And then non-business has its own lawsuits, right? There's car accidents. Well, maybe the insurance company may not want to cover you if you're texting and driving. There's people who get injured in real estate. You may have a $10 million umbrella, but did you know that if you lived in Florida, if you read the insurance policy on page 37, and I'm making this up in 4-point font, mold is only covered up to $5,000. My dad used to tell me growing up, the big print giveth, the small print taketh away. I can go on and on and on. You hear the crazy lawsuits when a burglar, goes into your house and gets injured and they still sue you. You're never short a lawsuit. And, there's divorces, so, lawsuits unfortunately just never end. And it's terrible because, they're supposed to be there to keep society fair. But unfortunately, people use them as a lottery ticket. They know that they can go to any lawyer within a mile of where they live, and that lawyer will more than likely take the case for free. And the other side that they sue is going to have to pay someone to defend themselves, so they might as well just settle and give them money. It's unfortunately become the free lunch. And again, not all lawsuits are bad, but the frivolous ones really get to me.
Yeah, definitely. Okay, so it sounds like a lot of HR type things, and I think that list would sounds fascinating. I would love to see that list. I'm wondering if someone is going to, instead of selling a business, buy a business, are there any of these principles that can help them see what they could expect from a really credible buyer, someone who's protected themselves and thought things through? Is there anything that they can learn from that?
Yeah, so it's always the opposites, right? And one that with the left side of the spectrum and the other one's at the right side of the spectrum. So if you're buying a business, naturally, if you're buying a business for $30 million, you don't want to give the $30 million. You want to give as little as possible. You want to make sure you're really getting what you're bargaining and paying for. So if I'm a buyer, I want to put down as little as possible. I can put down 300,000. I want to put down 3 million. I want to put down 5 million. I want to make sure that the business actually performs before I pay that $30 million. Now, if I'm a seller and I sell for $30 million, I want my $30 million up front because I already almost know that person's not going to run the business like me, and it's not my fault, but they're going to use it as an excuse not to pay me. So when it comes to buyers, it's really just the opposite. The buyers want to pay as slow as possible. The buyers want to have as many holdbacks as possible. The buyers maybe want to give you, instead of money, ownership of the company, where now, even though you sold the company, you still, want to see it succeed, and, you're going to help work because of that. But two totally opposite spectrums. And it's funny because, when you see business brokers, and we deal with a lot of great business brokers, a lot of the Vistage members ask us, and we'll refer them to somebody, depending on if it's a business broker for the seller or for the buyer. It's funny because they're two totally different extremes. To me, a business broker should either specialize in selling the business or buying a business, because there's tricks of the trade to both ends.
Okay, thank you. So if someone has real estate loans that require a personal guarantee, how do I take most of the assets out of my name? How do you get those out of the
Sure.
name?
So there's nothing wrong with that. And I own lots of real estate. I love real estate. I buy as much as I can, but I would never buy real estate in my name. A, I don't want to lose it, and B, I don't want to be sued if someone gets injured. So what you do is you just have to educate the bank. So for example, if we buy a piece of real estate in an LLC, and maybe the LLC is owned by a holding company, well, when you go to get the loan, you tell the bank that. Well, the bank now is probably going to want your personal guarantee, which if you protected yourself is really worthless. And they may also want the LLC and or the holding company to also sign on the loan. So the banks have no problem with it. They just want to make sure that they have the right guarantors in case anything happens.
Interesting. And you talked about homesteading. That applies to only your primary residence. Is that correct?
Correct. So for example, in Florida, where they have homestead, and they have it in other states like Texas and Puerto Rico, you have to be a Florida or Texas or Puerto Rico primary resident, and that has to be your primary residence. So I can't live in New York for 9 months out of the year and think I'm going to buy a house in Florida that's protected. I would need to buy a house in Florida, live here at least 6 months of the day, make that my primary residence, and then the Florida house could be protected. And even if it's not protected by homestead, it's fine. There's tons of things we can do as asset protection attorneys to protect it. It just wouldn't be automatically protected by homestead.
Okay, excellent. All right, hello, we've reached the end of our questions for today. So I want to thank you for being here, giving us a lot to think about. And this recording will be available within the next 24 hours, and we'll be sharing this with the broader Vistage community so they can gain access to the insights as well.
Thank you so much for having me, and I really hope it was timely, educational, and valuable.
Fantastic. Thank you, Hillel. Also, be sure to join us next Friday at our National CEO Conference, Business Growth. This is December 9th, and our keynote speakers are Shark Tank's Barbara Corcoran. Very excited to hear her insights, as well as innovation expert Martin Lindstrom. More information is available at vistage.com/growth2022. And we also hope to see you at our final webinar of the year, which is a member roundtable we're assembling, talking about wages and compensation. That's been a hot topic among CEOs. It's the top inflationary pressure. Wages are something used to drive retention, part of acquisition, and members are really thinking about how they can structure their wages and compensation going into the next year. So we'll have 3 members who are sharing their approach, and that's going to be on Friday, December 16th. You can register for this session and more at vistage.com/webinar. That's vistage.com/webinar. So thank you everyone for your time and attention today. Be safe and be well.